Difference between judgment, decree and order. So judgment means the statement made by the judge based on decree or order, and it is given in section 2 subclause 9 of CPC. Decree means the formal expression of adjudication that conclusively determines the right, and it is provided under section 2 subclause 2 of CPC. Now order is the formal expression of decision, and that is not a decree. Order may be preliminary decree or final. Decree may be either preliminary or final. Order is always whether final order or interlocutory order. Now what are the essentials? First is a concise statement of case, point for determination, decision of point, reasons and decisions granted. So when we talk about judgment, the judgment have the following thing, that is the fact, the issues of determination, the reasons on each issue. But when we talk about the decree, it mainly contains the adjudication, suit, determination of rights, conclusive and formal expression. Now when we talk about order, it is formal expression and it is not a decree, but it is issued by the civil court. Now types, so no specific types of judgment are there, but when we talk about decree, there is preliminary decree, final decree, partly preliminary and partly final, and deemed decree also. When we talk about order, there is final order, interlocutory order, appealable order and non-appealable order. Now judgment themselves are not appealable, but decree is only appealable. Now when we talk about decree is appealable under normal circumstances. Even second appeal also lies. Now here when we talk about orders, only certain kinds of orders are appealable under section 104 and order 43 rule 1. Finality, so it forms the basis for a decree and order and not final on its own. Here it conclusively determines the rights and final and accepted when it is not appealed. If it is appealed, then it may be changed or reversed. May or may not be final depending upon the nature of the order. Now it provides the reasoning for the court's decision. It concludes the rights of the parties in a civil suit. It addresses procedural or substantive issues, may or may not conclude the rights. I have already given you the answer. Order may be regarding injunction. Okay. So a petition can be filed under order 39 rule 1 and 2 seeking for injunction. So that is considered as an interlocutory order, and it can be appealed if mentioned under order 39. Okay.